On May 5, 1884, 4 men set out in a small yacht called the Mignonette, planning to sail it from England around the tip of South America to Sydney, Australia, where they would deliver it to its new owner. The 4 sailors were Captain Tom Dudley, mates Edwin Stevens and Edmund Brooks, and a 17-year-old cabin boy named Richard Parker. 2 months later, on July 5th, the Mignonette suddenly sank in a violent storm in the middle of the South Atlantic. The crew found themselves marooned in a tiny lifeboat more than 1,600 miles from any land, with only 2 tins of turnips and no drinking water. They managed to catch a turtle, which sustained them for a few days, but their situation quickly grew dire. By the 8th day adrift, the men were reduced to drinking their own urine. A week later, Richard Parker began drinking seawater, and his condition rapidly deteriorated. As desperation set in, Captain Dudley, Stevens, and Brooks talked about drawing lots to decide which of the 4 men would be sacrificed so the others could eat his body and survive for a while longer. But they couldn't agree about the details, and Brooks opted out of the plan altogether. On July 24th, with no hope of rescue, and with Parker delirious and hovering near death, Dudley and Stevens made a fateful decision. And their decision ultimately led to one of the most important cases in the history of Anglo-American criminal law. The case of Regina versus Dudley and Stevens is the classic introduction to a first-year criminal law course. It's the very first criminal case most students read in law school. In this course, we're going to learn all about criminal law, how crimes are defined, how the criminal law tries to ensure that only the truly deserving get convicted and punished, and how various institutions, including legislatures, prosecutors, defense attorneys, courts, and juries, work together to achieve society's goals and the ends of justice. We're also going to learn about criminal procedure, about the legal rules, mostly derived from the Constitution, that try to make the investigation, prosecution, and adjudication of a criminal case as fair as it can possibly be. I hope you're ready to join me on this fascinating journey. Let's return now to that tiny lifeboat and those desperate men stranded in the South Atlantic. And I apologize in advance, but this is going to get a little bit graphic. That's actually one of the challenges of teaching criminal law, because sometimes you got to talk about the terrible things that people do to one another. Anyway, here's how Captain Tom Dudley himself later described what happened next. No vessel appearing on the morning, I made signs to Stevens and Brooks that we had better do it. But they seemed to have no heart to do it. So I went to the boy who was lying at the bottom of the boat with his arm over his face. I took out my knife, first offering a prayer to God to forgive us for what we were about to do and for the rash act, that our souls might be saved. And I said to the boy, "Richard, your time is come." The boy said, "What, me, sir?" I said, "Yes, my boy." I then put my knife into the side of his neck. The blood spurted out, and we caught it in the bailer, and we drank the blood while it was warm. We then stripped the body, cut it open, and took out his liver and heart, and we ate the liver while it was still warm. 5 days later, having drifted for a total of 24 days, the 3 remaining survivors of the Mignonette were miraculously rescued by a passing German ship. When they returned to England, Tom Dudley and Edwin Stevens, but not Brooks, who'd opted out of the plan, were charged with murder. This was an unusual move. There were many shipwrecks in those days. The same year the Mignonette went down, almost 400 ships were lost at sea. Although cannibalism was rare, it wasn't unheard of when sailors were stranded at sea. And if those responsible survived, the law mostly looked the other way. But once the story of the Mignonette got around, the authorities decided it was time to put a stop to the practice of cannibalism once and for all. The criminal case against Dudley and Stevens became the biggest public sensation of its day. Now, there was no doubt that Dudley and Stevens, acting together, intentionally caused the death of Richard Parker. Dudley did the deed by his own hand, and Stevens was an aider and abettor because he supported the idea, thus encouraging Dudley to go through with it. The two men fit squarely within the legal definition of the crime of murder, unless they could offer up some kind of defense. At trial, Captain Dudley candidly told the whole story about what happened in that lifeboat. He did so because he assumed he wouldn't be convicted or punished based on the well-established legal defense of necessity, namely that the killing of Richard Parker was necessary to save the lives of the others and therefore was not a crime. The jury, after deliberating, surprised the court by handing down a so-called special verdict. The jury concluded that all of the relevant events happened exactly as Tom Dudley described them, but declined to make any decision about guilt or innocence. The jury instead kicked the case back to the court, asking the judges to make a legal ruling about whether the necessity defense applies to the crime of murder. The 5 judges of the Queen's Bench soon issued their decision. Lord Coleridge wrote the unanimous opinion finding Dudley and Stevens guilty of murder and sentencing both men, as English law then required, to death by hanging. But why? What purpose would be served by hanging Tom Dudley and Edwin Stevens? Criminal law is often thought to serve various purposes. One purpose is retribution, which means giving a convicted defendant the punishment he deserves in light of the crime and the defendant's moral blameworthiness. But were Dudley and Stevens murderers in any normal sense of that word? Did they derive any pleasure or moral satisfaction from what they did? Did their acts reveal a truly heinous or evil character? Or were they simply two average human beings, driven by unspeakable conditions to commit an unspeakable act? Can we really be confident that if we'd been trapped in that lifeboat, literally starving to death, we would have done any better? In the court's opinion, Lord Coleridge wrote eloquently about the moral dimensions of the case. Though law and morality are not the same, and many things may be immoral which are not necessarily illegal, yet the absolute divorce of law from morality would be of fatal consequence. To preserve one's life is, generally speaking, a duty, but it may be the plainest and the highest duty to sacrifice it. Lord Coleridge acknowledged that the defendants were subject to terrible temptation, to sufferings which might break down the bodily power of the strongest man and try the conscience of the best. But he also noted, we are often compelled to set up standards we cannot reach ourselves and to lay down rules which we could not ourselves satisfy. So maybe the idea of retribution does apply to Tom Dudley and Edwin Stevens. They may not have been any better or any worse than the rest of us, but that's not an excuse for what they did to Richard Parker. And according to Lord Coleridge, that makes them deserving of criminal punishment. What about incapacitation, another purpose behind the criminal law? Sometimes we put dangerous people in prison or even execute them just to make sure that they aren't free to commit more crimes. But it seems strange to apply that rationale to Dudley and Stevens, because unless those two men somehow got shipwrecked again and marooned at sea again, there's no reason to think they would ever kill again. For the same reason, rehabilitation doesn't seem applicable to Dudley and Stevens. And in any event, the death penalty isn't really very much about rehabilitation, unless you're persuaded by the words of Samuel Johnson, who once observed, "When a man knows he is to be hanged in a fortnight, it concentrates his mind wonderfully." By the way, rehabilitation was once a major goal of the American criminal justice system, hence the use of terms like reformatory and penitentiary to describe prisons. But during the 1960s, Americans became cynical about the prospect of rehabilitation and largely gave up on the idea. That's not so in other parts of the world. For example, in modern Japan, pretty much the entire criminal justice system is designed to help convicted criminals realize the error of their ways and prepare to re-enter society as law-abiding citizens. What about deterrence, yet another purpose of the criminal law? Was it necessary to hang Dudley and Stevens to deter others from doing the same thing under the same circumstances? Deterrence sounds plausible at first, but think about this. Could any threat of legal punishment, even the death penalty, ever manage to deter someone who's already staring death straight in the eye? But maybe that's not really the focus of the deterrence in this case. Maybe the goal isn't to deter someone else who actually ends up in the same dire circumstances as Dudley and Stevens. Maybe that's not possible. But maybe the law still needs to lay down a clear rule to deter others in the future from choosing to become judge, jury, and executioner of someone like poor Richard Parker under circumstances that might not be quite as dire. As Lord Coleridge explained, who is to be the judge of this sort of necessity? By what measure is the comparative value of lives to be measured? Is it to be strength or intellect or what? It is plain that the principle leaves to him who is to profit by it to determine the necessity which will justify him in deliberately taking another's life to save his own. Such a principle, once admitted, might be made the legal cloak for unbridled passion and atrocious crime. In other words, even if Dudley and Stevens, and those in similar straits, couldn't possibly be deterred by the law, maybe we need to make an example of them anyway, because otherwise, the necessity defense could provide others with the opportunity to get away with murder. In the end, Dudley and Stevens were sentenced by the court to hang. But Lord Coleridge also added, if the law appears to be too severe on individuals, we leave it to the Queen to exercise that prerogative of mercy which the Constitution has entrusted to the hands fittest to dispense it. And that's precisely what happened. The Queen commuted the death sentences of Tom Dudley and Edwin Stevens to 6 months in prison. Dudley and Stevens is a wonderfully rich case, with facts worthy of a Hollywood movie and a legal opinion that reads like a learned treatise in moral philosophy. And the holding in the case, that the necessity defense can't be used to avoid a charge of murder, because no person is entitled to take another's innocent life even to save his own, remains true in both English and American criminal law right up to the present day. Moreover, the idea that executive clemency sometimes should be used to mitigate the harshness of the criminal law also remains totally valid today. State governors, and in the federal system, the President of the United States, still possess the very same power to commute sentences and to pardon convicted defendants that the Queen of England enjoyed in 1884. Nowadays, the executive rarely grants clemency, because most politicians don't want to be seen as soft on crime. But there's another kind of executive discretion that's grown up to take its place. I'm talking here about the power of the prosecutor to offer a plea bargain that, in exchange for the defendant's guilty plea, drops some charges or reduces the sentence. Plea bargaining today accounts for almost 95% of all criminal convictions. Trials are a rare exception, not the rule. In short, Regina versus Dudley and Stevens continues to be relevant to modern criminal law. That's why we still teach the case in law school. However, in a number of important respects, Dudley and Stevens is not at all representative of the real world of American criminal law today. For one thing, murder is an exceptionally unusual crime. In the United States, for every person arrested and charged with murder, nearly 1,000 people are arrested and charged with other less serious crimes. The largest single category of crimes for which people get arrested is the possession, sale, and use of illegal drugs. Second on the list is larceny or theft, followed by driving under the influence, simple assault, public intoxication, and disorderly conduct. Most of the day-to-day practice of criminal law isn't about serious violence. Instead, it's mostly about low-level drug crimes, property crimes, and crimes against the public order. Another key difference is that the Dudley and Stevens case arose during the era of common law crimes. As you may already know, the term common law refers to law as made by judges through the individual decisions those judges render in individual cases. America inherited its legal system from England, and many areas of Anglo-American law, including contract law, tort law, and property law, evolved over the centuries through the common law process. And so too did criminal law. That's why the judges in Dudley and Stevens were required to define the crime of murder and to decide whether or not the necessity defense could apply to that crime. There was no other place to look for the answer. It was completely up to the judges. But that's not the way criminal law works in America today. During the early 20th century, a reform initiative to codify the criminal law swept America. The basic idea was that people should be able to look up the definition of a crime in a statute and learn exactly what kind of conduct is prohibited. As a result of this codification movement, in modern America, all crimes are defined by statutes enacted by legislatures. We no longer permit judges to define new common law crimes. So today, in America, a case like Dudley and Stevens would inevitably start with the text of the relevant crime statute that defines the specific elements of the crime, the elements that must be proved by the prosecution at trial beyond a reasonable doubt to secure a conviction. By the way, I should point out that almost all crimes in America, more than 90% of them, are defined as crimes under state law, not federal law. That's because our federal government is strictly limited to exercising only those powers granted to it by the Constitution. And the Constitution doesn't give Congress the power to enact general crime statutes. During the common law era, criminal law was mostly a private matter. For most of English legal history, crimes were not prosecuted by a public official called a prosecutor. In fact, until the late 1700s, there was no such thing as a public prosecutor. That institution originated in the American colonies. In pre-colonial England, crimes were prosecuted by the victim or by a member of the victim's family. The victim would hire a private lawyer and press criminal charges, sort of like filing a civil tort lawsuit. In the American colonies, the legal authority to file criminal charges gradually migrated from victims to the new public prosecutor. And that remains the rule today. The American criminal justice system no longer allows for private prosecutions. Criminal law has become the sole province of the government, acting on behalf of society as a whole rather than on behalf of crime victims. In modern America, as a result of these gradual changes over time, we can say that crimes are defined by the complex interaction of several different institutions. First comes the legislature, which enacts the statute that provides the formal definition and identifies the required elements of the crime. Next comes the prosecutor, who, working closely with the police, oversees the criminal investigation and ultimately makes the decision that, based on the evidence, a particular individual should be charged with a particular crime. Any person who's been formally charged with felony crime has a constitutional right under the Sixth Amendment to be represented by a defense lawyer. If the defendant can afford to hire a lawyer, he'll usually do so. If he can't, then he'll be represented by a lawyer who's paid by the government, either a private defense lawyer willing to take the case, or, especially in larger cities, by a public defender who works for a government agency with the official responsibility to provide legal aid to indigent criminal defendants. Once the defendant has a defense lawyer, the prosecutor will begin to negotiate with a defense lawyer about a possible plea bargain. Remember, that's how the vast majority of criminal cases, almost 95%, get resolved. So defense lawyers also play an indirect role in defining crimes. If the two sides can't agree on a plea bargain, then the case will go to trial. In all criminal cases where a defendant could get more than 6 months in prison, the defendant has a constitutional right to a jury trial. Jury trials are rare, but the jury still plays a key role in defining crimes, because the jury possesses the absolute and legally unreviewable power to acquit, even in the face of overwhelming evidence of guilt, if the jury believes that the behavior of the police or prosecutor or the criminal law itself is unjust. Last but not least, there's the role of the judiciary. Every criminal trial occurs under the supervision of a trial judge, with the authority to dismiss the charges if the judge concludes that the evidence of guilt is insufficient to meet the prosecution's burden of proof beyond a reasonable doubt. Every guilty plea, including the terms of any plea bargain, also must be approved by the judge. And judges, both at trial and even more so on appeal, serve as the official interpreters of the law, including both the crime statute and any defenses or constitutional provisions that might come into play. To summarize then, defining crimes requires the involvement of legislatures, prosecutors and police, defense lawyers, juries, and judges. But because everything starts with the crime statute, and because everything usually ends with a plea bargain, the legislature and the prosecutor have become the key players in defining crimes today. Meanwhile, and contrary to the way things are portrayed in courtroom dramas on TV and in the movies, the relative importance of juries, and especially of judges, has gradually diminished over time. This shift in the institutional balance of power can be observed in many modern criminal law cases. One great example is the 1998 case of Brogan versus United States. James Brogan was a union official suspected by the FBI of taking bribes from the company to sell out the interests of the union. One evening, federal agents knocked on Brogan's door. And when he answered, the agents identified themselves and told Brogan they were seeking his cooperation in a criminal investigation. The agents asked Brogan if he had taken bribes. Brogan replied, no. The agents, who already possessed documents proving that Brogan had in fact taken bribes, then arrested Brogan. He was charged with bribery and also with violating a federal statute, 18 U.S. Code Section 1001, that prohibits making false statements to the federal government. The false statement crime statute provided, whoever, in any matter within the jurisdiction of any department or agency of the United States, knowingly and willfully falsifies, conceals, or covers up a material fact, or makes any false, fictitious, or fraudulent statements or representations, shall be fined not more than $10,000 or imprisoned not more than 5 years, or both. Brogan was convicted at trial, and he appealed all the way to the U.S. Supreme Court. Brogan's lawyer argued that the court should create a special exception to the false statement crime for someone who, like Brogan, utters a simple no in response to a question from a government agent about whether he committed a crime. This proposed exception, described as the exculpatory no defense, had already been recognized by several lower federal courts, but had not yet been ruled upon by the Supreme Court. Brogan's lawyer argued that the exculpatory no exception was necessary to avoid putting people like Brogan in the position of being pressured by the government into admitting their own guilt, which would violate the spirit, if not the letter, of the Fifth Amendment privilege against compelled self-incrimination. And Brogan's lawyer also pointed out that Brogan didn't actually mislead those federal agents, because the agents already knew perfectly well that Brogan was guilty of taking bribes. The Supreme Court, by a vote of 7-2, upheld Brogan's false statement conviction. According to the majority opinion, written by Justice Antonin Scalia, by its terms, Section 1001 covers any false statement. The word no, in response to a question, assuredly makes a statement. In fact, Petitioner Brogan concedes that under a literal reading of the statute, he loses. Petitioner asks us, however, to depart from the literal text that Congress has enacted and to approve the doctrine which excludes from the scope of Section 1001 the exculpatory no. It is not and cannot be our practice to restrict the unqualified language of a statute. Courts may not create their own limitations on legislation, no matter how alluring the policy arguments for doing so. Because the plain language of Section 1001 admits of no exception for an exculpatory no, we affirm the judgment. This is the essence of modern textualist interpretation of crime statutes. The United States Supreme Court, the highest court in the land, felt powerless to consider the argument that Congress wouldn't want the false statement crime to apply to someone who merely utters a simple exculpatory no. Instead, the court found the plain language of the statute completely conclusive. Because the text of the statute makes no reference to an exculpatory no defense, the defense can't exist. End of story. This is clearly a far cry from the kind of freewheeling moral philosophical discussion about the proper scope of the necessity defense that we saw in Lord Coleridge's majority opinion in Dudley and Stevens. If Dudley and Stevens represented judging in the bygone era of common law crimes, Brogan represents judging in the modern era of textualism. Textualism has had two primary practical effects on the criminal justice system. One practical effect is that the system has become more punitive in terms of both the breadth of the criminal law and the severity of criminal punishments. This occurred because legislators are politicians, and no politician ever got elected by being soft on crime. Politically speaking, legislatures always have a strong incentive to enact ever broader and ever tougher crime statutes. And for decades, our state and federal legislatures have done exactly that, which helps explain why America's prison population has exploded since the 1960s. Only when prison populations exceed prison capacities, forcing tax increases to build new prisons, do legislators start to think twice about being so tough on crime. Textualism also has had the practical effect of greatly increasing the power of prosecutors. If even the Supreme Court can't save a defendant like Brogan from the literal interpretation of a crime statute like the federal false statement statute, then who can? For someone like Brogan, the best shot at leniency, indeed perhaps the only shot, is to cut a favorable plea bargain with the prosecutor. Prosecutors have learned how to use effectively the leverage they've gained as a result of the shift in power from judges to legislatures. That's why our plea bargain rates continue to climb, because defendants know that these days the prosecutor is just about the only game in town. Now, notwithstanding these modern trends in favor of legislatures and prosecutors, judges do still retain power over one key aspect of criminal law, namely the traditional requirement that all defendants must be proven to have acted with evil intent, sometimes described as an evil mind, or in Latin, mens rea. As a matter of general principle, we don't want to convict someone of a crime unless they deliberately did something truly wrong, truly immoral, truly evil. Indeed, this is often identified as one of the basic requirements for any valid crime. The defendant must commit a voluntary act, or an omission, with an evil mind that either causes or creates a risk of causing harm to a person, to property, or to some other tangible or intangible interest protected by the law. But most modern crime statutes don't address the specific mens rea requirements for a particular crime. Legislatures tend to focus their attention mostly on defining the criminal act, or actus reus, rather than on the mental aspect of the crime. Does the prosecutor need to prove that the defendant committed the prohibited act intentionally? Or is it enough to commit the act recklessly or negligently? These kinds of questions tend not to be answered by the text of most crime statutes, which means that judges have to keep filling in the gaps, just like they did back in the days of common law crimes. It's the one area where textualist statutory interpretation won't work, because the legislature usually doesn't provide any text. The judicial power to define and apply the mental or mens rea requirements of crimes, which includes the power to decide about such related matters as self-defense, intoxication, and the insanity defense, means that judges can still pursue the ends of justice in individual criminal cases. So, maybe the core of criminal law hasn't really changed all that much since the days of Dudley and Stevens. Because Lord Coleridge didn't have to deal with a rigid crime statute, he was free to make whatever decision seemed right in light of the facts of the case and the goals of the criminal law. Judicial discretion today is much more limited. Yet, even in a textualist era, where statutes and plea bargains tend to dominate, judges can still find ways to reverse criminal convictions that seem unfair. And that's a good thing, because in the end, criminal law is all about justice to the defendant, to the victim, and to society.